president needed to prevent these people from entering the country. And therefore, though Trump had an executive order to establish this policy, the argument was that he was just doing what he had to do under the statute. But in this case, by a close 5-4 decision, and a couple of the conservatives, actually went with the liberals on this case. They said, well, actually, the language is not mandatory shall; it's permissive may. And therefore, if that's what it means, even though I think Kavanaugh was the one who sided with the liberals here, says, yeah, I wish that that Biden would not use this executive order, but I think it's a may. I don't think it's a shall. And so, because of his intellectual honesty, he ruled that the executive order of Biden was valid, even though it advanced a view with which he disagreed. And he did signal that upon remand, there may nevertheless be a way to require the government to keep immigrants from coming into the country, because he said in this law, the administration can only allow them to come in if it can prove that their coming in provides a significant benefit to the public. And he says, whether they can, we don't know. That's going to be another case. One other case that I want to briefly mention is Kennedy versus Bremerton School District, a case coming from the state of Washington. This is the case where a coach named Kennedy was fired as a coach because he would pray silently in the middle of the football field after a game. And his school district forbade him from engaging in any overt actions that could appear to a reasonable observer to endorse prayer while he was on duty as a district paid coach. I'm quoting language from the Supreme Court. In other words, it was okay for him if he would go where nobody would see him and pray. But if he would go in the middle of the field after the game and bow his head and offer silent prayer, that would be seen as engaging in supporting religious conduct. And he was fired because they said he violated the Establishment Clause of the First Amendment. The Supreme Court reversed and said that's nonsense, and his free speech rights were violated. So he had a free speech right under the Free Exercise Clause that prevailed over the state of Washington's argument that by doing this silent prayer in the middle of the field, that was a violation of the Establishment Clause. Of course, other things that were going on as a coach, when he would pray this way, some of the kids would come and pray with him or meditate with him. And so people didn't like that. Anyway, this was an important case because it represents the efforts by some people to eliminate all vestiges of religion and belief in God from our public discourse and from schools. And there is some weighing and judging of what you can and cannot do. But what the school district did to Mr. Kennedy was wrong, and the Supreme Court vindicated him. In conclusion, the state of the Supreme Court is strong and good. A solid majority currently embraces good conservative principles about the limited value of the Supreme Court that is in conformity with the view of the founders and certainly my view, and which gives more authority to the states and the people and prevents the Supreme Court from becoming just a super legislator that mandates that their views be accepted. The current Supreme Court, a solid majority, recognize that they need to defer their views and establish those that the Constitution requires. That concludes our discussion for today. Remember that the liberties that we enjoy in America can be maintained only when its citizens are moral and informed participants in the democratic processes. The closing argument helps us to do this. We'll see you next time. This is Paul Smith.